Hey everyone, Todd Vandermight here for Freedom Steel. This is Down and Dirty, a real quick breaking news. Cue the alert. The Seventh Circuit Court of Appeals in a 2-1 decision this afternoon has upheld, that is upheld, Illinois' semi-auto ban. This is a 95-page decision with a dissent, and you have Judge Woods and Easterbrook on one side. So Woods wrote the opinion, who was a Debbie Downer in the Atkinson decision we saw. So let me quote a few things here as to why I think it's a bad decision. But the Second Amendment to the Constitution recognizes an individual right to keep and bear arms. Of that, there can be no doubt in the wake of the Supreme Court's decision in District of Columbia v. Heller, McDonald v. Chicago, Catano v. Massachusetts, and New York State Rifle and Pistol Association v. Bruin. But as we know from long experience with other fundamental rights, such as the right to free speech, the right to peaceably assemble, the right to vote, the right to free exercise of religion, and even most important personal rights such as free speech, personal freedoms have their limits. Government may push a deliberative false alarm. It may condition free assembly on the issuance of a permit. It may require voters to present a valid identification card, and it may punish child abuse even if it's done in the name of religion. The right enshrined in the Second Amendment is no different. The present cases which have consolidated for disposition relate to the types of arms that are covered by the Second Amendment. This presents a line-drawing problem. Everyone can agree that a personal handgun used for self-defense is one of those arms that law-abiding citizens must be free to keep and bear. Everyone can also agree, we hope, that nuclear weapon, such as the now retired M388 Davy Crockett system, with its 51-pound W54 warhead, can be reserved for the military, even though it's light enough for one person to carry. Many weapons, however, lie between these extremes. The state of Illinois and legislation that lies at the heart of these cases has decided to regulate assault weapons and high-capacity magazines, a decision that is valid only if the regulated weapons lie on the military side of that line and thus are not within the class of arms protected by the Second Amendment. Several municipalities have done the same. The plaintiffs in these cases challenge that conclusion using the tools of history and tradition to which the Supreme Court directed us in Heller and Bruin. We conclude that the state and the affected subdivisions have a strong likelihood of success in the pending litigation. We therefore affirm the decision of the district courts in Appeals 23-1353 and 23-1793, refusing to enjoin these laws, and we vacate the injunction issued in District Court Appeals 23-1825, 1826, 1827, and 1828. We conclude with a few remarks about several additional issues in some of these cases that do not require immediate attention, and a reminder about the limits of our ruling. First, we briefly comment on Herrera's challenge to the constitutionality of registration requirement that implements a grandfather exemption. He regards it as a burden on its Second Amendment rights, and he worries that it may in future lead to confiscatory acts on the part of the state. If we are correct in our prediction that the state will prevail in its defense of the act against the Second Amendment arguments, then the registration requirement will be valid as long as it can withstand rational basis review. Bing, bing, bing! This is a red flag. At this juncture, we see nothing particularly onerous about it, though, as with everything we have said, this is a preliminary assessment. Herrera has until the end of 2023 to file the necessary forms, and if he does so, he may retain all of the covered weapons he already owns. The act will prohibit only his acquisition of additional assault weapons or high-capacity feeding devices. For its own reasons, the dissent agrees with us that the registration requirement should not be enjoined. So there you have it. Boys and girls, moms and dads, children of all ages, We have a decision out of the Seventh Circuit Court of Appeals. So this now puts us ahead of the California cases, the Maryland cases, and all the others. And where this is going to go, my bet is there are going to be several parties here that take it to the Supreme Court. That we are not going to wait for an en banc panel. We're not going to play that game. And SCOTUS, here we come. Today, SCOTUS took on a case dealing with bump stocks. So 2024 could be the year of the Second Amendment. This is a 95-page ruling. I have just excerpted 2 paragraphs out of this ruling. So I'm going to sign off now, get this up there, and I will be back later tonight with more on the subject. As always, frag out.